Happy Tuesday. I'm Anjanette Levy coming to you with a kind of last minute pop-up live. I was going to come on here and just talk simply about the Karen Reed case, but then something dropped in the Brian Kohberger case, so I'm going to talk about that too. So if you're joining me for the first time or watching for the first time on replay, thanks a lot. I really appreciate it. Please hit the thumbs up button for me and subscribe. I'd really appreciate it. So let's get to the Brian Kohberger news first. I think some people will probably be watching on replay because I did schedule this kind of last minute. So Brian Kohberger has made several attempts, or really 3 attempts to strike the death penalty in his case. And one was for the autism spectrum disorder. He said, the death penalty should be stricken because I have autism spectrum disorder. Judge Hippler denied that. And then his third attempt to strike the death penalty was citing the voluminous amount of discovery in this case. There's 68 terabytes of discovery that have been handed over. That's a huge amount of discovery that's been handed over to Brian Kohberger's defense team in this case. And they say we simply can't get through it all before trial. The state's handed it over in a haphazard manner. And so in the Lori Vallow's case in Idaho, discovery was handed. Hello, 12 gauge investigative. Thanks so much for coming in. And Glitter is Forever. Thank you. Hi. Thanks for joining my last minute kind of pop up live. I appreciate it. I'm kind of, I felt like I should just kind of wing it and do one of these once stuff started popping up. In Lori Vallow's case, there was material handed over really late in the game. So Judge Boyce struck the death penalty from Lori Vallow's case. And so Brian Kohberger's lawyers have said, pointed to that case and said, well, in the Vallow case, there was only 5 terabytes of discovery. And so you should do the same thing. This is the only remedy that can, cure this awful thing that's been done. Well, guess what? Judge Hippler said no dice. This was brought up in the hearing in early April. This came up and there was some back and forth about it. And maybe we should discuss this in further detail, maybe Friday night, Saturday night. I'm not sure. We'll probably come up with something this weekend where we can talk about it and go through the hearing a little bit. But Judge Hippler does not believe that Brian Kohberger has been so prejudiced by this huge amount of discovery they've received and the way it's been handed over. Ann Taylor said it's been handed over in like a piecemeal fashion. And he's just saying, no, I'm not striking the death penalty because of this. Remember, guys, to please hit that thumbs up button for me. I really appreciate it to kind of support my little channel here. I'd really appreciate it. So let's share my screen and then we'll pivot to Karen Reed because there's been a bunch of things that have happened. And we can get into it more later in the week, I guess. There's been a lot that's happened. The cell phone stuff is, there's a lot that goes into that with the Celebrate expert. But, hi, Iborski. So let me share my screen and show you what Judge Hippler wrote. Okay. Defendant contends that the discovery produced by the state in this case has been voluminous and unorganized, thus rendering him unable to meaningfully review and investigate the state's evidence in time for trial. Asserting his due process rights have been violated, defendant seeks sanctions in the form of striking the death penalty and imposing certain organizational requirements upon the state to aid defendant's review of discovery. The state responds that it has complied with all discovery obligations, including Brady, and there is no basis for sanctions or other measures. Hippler talks about how oral argument was held on this motion on April 9th, after which the court took the matter under advisement because defendant has failed to show a discovery violation or due process violation by the state. Sanctions are not warranted. The court further declines to require the state to provide further organizational assistance to the defendant. So what I find so interesting about this is because I cover the Pike County case. For those of you guys who might not be aware of that case, it's the case in Pike County, Ohio, where, George Wagner, or the Wagner family Some of them have pleaded guilty. Some, only one, Billy, is left to go to trial. George was convicted, but he says he's innocent. Jake and Angela pleaded guilty, and they're serving time in prison. There was a lot of discovery in that case, and this was a common complaint. There was terabytes and terabytes of evidence in that case. And so they even talked about in that case hiring a discovery coordinator. The judge didn't want to spend the money on that, and they figured out how to handle all of this discovery. But they can bring somebody in who's a coordinator and who can kind of sort all of this out and make sure everybody gets what they're supposed to be getting. Why that wasn't brought up in this case by the defense, and they've complained about discovery in the past, but why they didn't bring that up before boggles my mind, because that is something that can be done. So Judge Hippler kind of spanked Ann Taylor a little bit. Defendant complains that the state has failed to satisfy its obligations under Brady v. Maryland due to its method of discovery production. He contends that the state has turned over more than 68 terabytes of data in discovery, consisting of in excess of 13,000 photographs, 15,000 video clips from businesses, and 8,000 video clips from residences. It also includes more than 60 digital devices, digital data, and search warrant return data. Defendant also contends the state has not provided the discovery in a searchable format, has not provided detailed logs and indexes that would facilitate defense's review of the material, and has not specifically identified any Brady evidence. Defendant argues he's been prejudiced by the state's data dump, method of discovery, and contends that the sanctions are warranted in the form of striking the death penalty and excluding witnesses. He also asks that the court required the state to identify Brady material or hot documents within its discovery. While the state acknowledges there is a massive amount of data in this case, it contends the majority is completely irrelevant. Specifically, the state contends that most of the data is from cell phone extractions and weeks of surveillance footage throughout the Moscow area obtained following the homicides. It affirmed on the record that it is unaware of any Brady material in those videos other than those specifically identified in motion practice and otherwise throughout the case. Further, the state's experts who reviewed the various devices, including cell phones and other digital data, have disclosed opinions that they found no connection between defendant and the victims from the devices and data. So this is now the third, fourth, maybe fifth time that we have heard that yet again, through devices, data, they found no connection between Brian Kohberger and the victims in this case, which is, it's interesting. It's really interesting. The state also notes that since this case began over 2 years ago, it has continuously turned over to defendant all the information it received from the various investigating agencies in the same format as the information was received by the state. This was done at defendant's request, who specifically asked that the state produce everything the state had from the get-go. Defendant also issued 400 itemized requests for discovery in this case. Thus, the state contends it is on the same playing field as defendant regarding discovery. In addition, the state points out that on September 4th, 2024, at approximately the same time as its discovery deadline, it provided defendant with a 320-page index identifying the location of requested discovery, a description of the evidence, and the date discovered. In addition, all of the evidence received from the FBI, which comprises the majority, was provided to defendant with a searchable index. In sum, the state asserts it has provided everything required by Idaho Criminal Rule 16A and Brady, and disputes it has engaged in discovery violations. So he's saying there are no sanctions warranted. Then I'm going to go down to page 6. Hippler kind of spanks Ann Taylor a little bit. He kind of calls her out. And he did this a little bit in the hearing too. But he puts this in writing. Let me see if you guys are asking any questions yet. Hi, Webby. Oh, Webby, don't ever apologize. I appreciate you helping me out. Hi, everybody. So the Ann Taylor took on this case late December of 2022 when Brian Kohberger was charged. So this is a death penalty case with 68 terabytes of discovery. Now she took on another death penalty case. There's somebody named Skylar Mead who she's representing. And so Hippler questioned her about this in the hearing. Well, now he's like calling her out in these papers in this order. In addition, defendant's complaints of being unable to meaningfully review the discovery ring hollow. Defendant has been receiving discovery in the same manner for over 2 years. In that time, he has not once, and this is where I was talking about a discovery coordinator, not once sought a remedy from this court to regulate discovery, such as requiring the state to provide discovery in a different format. He has not sought additional resources to hire additional staff to review discovery or obtain litigation document control software to help organize and sort the evidence. His lead counsel insisted that she be allowed to take on a second high-profile capital case, despite the voluminous discovery in this case. So I'm kind of wondering if Brian Kohberger is convicted, let's say he is ultimately convicted. On appeal, is he going to say, my lawyer was ineffective? She took on another death penalty case. Why was she doing 2 death penalty cases? I was accused of murdering 4 people, and she took on some other case. I mean, it'll be interesting with all the motions they filed. Further, at oral argument, lead counsel indicated that her practice is to personally review all the discovery herself rather than rely on associates and staff to review materials to cut through the less relevant information and point to what materials need review by lead counsel. These actions are not indicative of an overburdened defense team. In fact, it is evident defendant has been able to capably navigate the discovery given his more than robust motion practice. Saying you guys have filed like 800 motions. You guys are good. The scope and breadth of the experts retained and the disclosures filed. Yikes. Okay. In the cases cited by defendant where the courts have struck the death penalty as a sentencing option, the defendant has demonstrated that the prosecution either willfully or inadvertently, but with extreme resulting prejudice, violated discovery obligations. Here, however, defendant has not established a discovery violation in the first place. He has not shown the state has attempted to conceal specific materials within the discovery, and he has not shown discovery to be unduly burdensome to the point where he is unable to examine the items that are material and of evidentiary value. Consequently, there is no basis for any sanction, let alone striking the death penalty. So he's literally... he kind of lashed out at her. So Brian Kohberger has now lost his 3rd attempt to strike the death penalty. What do you guys think about that? Hi, Melmac. Thank you so much for helping me out. I appreciate it. It seems to me like Judge Hippler really laid down the law and says you shouldn't have taken on a second death penalty case. He said that to her in the hearing a couple of weeks ago. Now he's really... letting her kind of have it. So what do you guys think about that? I'm going to take this down so you don't have to look at that piece of paper. It just seems to me like Judge Hippler is like, you have filed so much paper in this case. So you seem to be doing just fine getting through all this discovery, and you took on another death penalty case. Why are you complaining? Oh, and I just hit the thing. Gaia hypothesis, probably not more people here because I decided to do this at the very last kind of minute and hop on here. I was going to talk about Karen Reed because I'm like, I really need to get on there and talk about Karen Reed, and then this dropped, the Kohberger thing dropped. So yeah, that's why there's probably not more people here. Donna Berry says, I love this judge. You know what we can do later this week, guys? I'll pull up the hearing where this was discussed, and we can kind of go through it and watch Ann Taylor kind of explain all of this herself. So Melmac says, judge isn't going to allow much, in my opinion. Yeah, I think so. And Webby says he is calling / making good choices. So, again, guys, thanks for watching with me, or being on here with me and watching. I'm going to turn now to the Karen Reed case. We will pull up the hearing later this week where Judge Hippler basically was talking to Ann Taylor about this whole issue and how the state talked about how they organized their discovery, which boggled my mind because I know 68 terabytes. I don't know how anybody would organize that stuff. So let's pivot now to Karen Reed. Is everybody watching the Karen Reed trial? Because there's been a lot that's happened in the last 2 days. We're just going to talk about this briefly. Tayo Toys here with the jokes. Yeah, who is Karen Reed? And he puts an eye on there to make a joke. So Karen Reed, you know, she's this woman up in Massachusetts, accused of killing her boyfriend, a Boston police officer, John O'Keefe. So it's been interesting the last 2 days or so. Ian Whiffen, he is the Celebrate expert. He testified in the first trial. And so what's really interesting is the fact that he, you know, testified in the first trial about the 227 versus 6:23 or 6:24 a.m. Google search by Jen McCabe, house long to die in the cold. Ian Whiffen says that search happened at 6:23, 6:24. That's when that search happened. He talked about the issue with the software and how they rewrote the software, and there was an issue, and that's why it was showing up as coming up in Jen McCabe's phone as 2:27 a.m. And he said they got a call from Richard Green, who was the defense expert in this case. And he's saying, you know, why is this coming up like this? And it was also coming up that it was deleted. And he said, he gave an explanation in court about why it was showing up like that. There was also some discussion on cross-examination because I'm going to put this map up. On direct examination, he said it was his opinion that the phone of John O'Keefe didn't move. There were a bunch of red dots indicating the location of the phone, but it didn't move. Yeah, I'll get to that in a second. He said it didn't move from the flagpole, from like, you know, somewhere around 12:22, I believe it was. If I am misstating that time, I apologize, to when Carrie Roberts picked it up. After 6 a.m. when they found John O'Keefe, his body was picked up. She picked up his phone and took it away. So the flagpole is over here. Well, on direct or on cross-examination, Robert Alessi, Karen Reed's attorney, was asking some questions and asking if the phone's location could have been in, like, within one of these white circles. And Ian Whiffen said it could. And it almost sounded like Ian Whiffen was saying that John O'Keefe could have been, or John O'Keefe, my goodness, John O'Keefe. I'm kind of tired, guys. And I've got a little bit of a headache because of the storms coming in. But it was almost like he was implying John O'Keefe could have been in the garage of the home at 34 Fairview. So, you know, on cross, it seemed like Robert Alessi was really making some points and doing some damage. So let's look at a little bit of Robert Alessi's cross-examination of Ian Whiffen. He had explained on direct why they believed that search by Jen McCabe did not happen at 2:27 a.m. as the defense expert contends. He's saying it happened at like 6:23, 6:24, but he was cross-examined about it by Robert Alessi today. And this went on for a while, so these are just a couple of brief clips.
First proceeding in this case in June of 2024, when you testified under oath, the situation with the forensic tools was Celebrate Forensics Insights did not show the 2:27:40 a.m. timestamp, but another version of Physical Analyzer did show it, correct?
Correct.
In that second program, that second tool, Physical Analyzer, not only showed it at 2:27:40 a.m., but it showed it as a deleted state, correct?
It's a deleted record, yes.
A deleted record.
Yes.
Did you mention that yesterday in your direct testimony?
I don't believe so.
You don't believe so?
No, we changed it since then.
Exactly. You changed it since then.
Yes.
Your company removed it
Yes.
after the first trial.
Before the first trial.
Well, you removed it from one tool before the first trial, but you didn't remove it from the other physical analyzer program, did you?
Up until the following version was released.
No, I'm talking about the time of trial when you were testifying.
I appreciate that. There's some complexities with how we released the software, which resulted in one being released several weeks later and one being released several weeks earlier.
At the time of trial,
Yes.
last year in June, when you were testifying under oath, one of the Celebrite tools showed the timestamp of 2:27:40 a.m., correct?
Correct.
But that timestamp doesn't exist anymore. It doesn't exist today, does it?
Correct.
Celebrate removed it.
Yes.
You mentioned.
Could I say? Okay. So he's saying Celebrate removed it. I want to put this comment up from Phil. This is interesting. I didn't see that. I was only on X for a little bit today. Actually, I should pull up some of my X comments, or not my comments, but some of the comments at me, because people did not like what I had to say today about, it was just a thought I had about the ARCA witnesses and what could possibly happen. I tweeted it this morning and people didn't like it after the hearing yesterday, because there were some things I heard from Dr. Wolf where I was like, ooh, that was not good for the defense or for Dr. Wolf. But Tayo Toys says Celebrate turned off comments on X. They were getting harassed during Whiffen testimony. Let's check it out right now and see if it's still turned off. Their comments. Oh, accounts Celebrate mentioned can reply. Interesting. Yikes. Okay. So that's funny because I was hosting the Q&A lunch show on Law and Crime today, and people were like, is this a PR nightmare for Celebrate or what? And I think it kind of is, because, you know, Celebrate is like the gold standard, or it's supposed to be the gold standard. And this was really, you know, it seemed like this wasn't really going very well. And let me look at one of my notes that I wrote down. Let me pull up my notes. Ian Whiffen said it was possible that the phone was moving toward the house. He said that. And then he talked about low accuracy for location data, that it could have been closer to the house than the road. And he didn't include this in his timeline to the jury, but he put it in his report. So Alessi was going through his report. And then they were talking about battery temperature and how battery temperature can be used to determine the location of a phone. So that was pretty interesting too. So let's now go to the second clip about the 2:27 a.m. search.
Proceeding. There was one Celebrite forensic tool that still showed the 2:27:40 a.m. timestamp.
Correct.
And it was shown in a deleted state.
The record was deleted, yes.
The record was deleted. And then after that, Celebrite outright removed the timestamp from so none of its programs had it. Correct?
Again, if I could explain a little bit about how it works.
No, I'm sorry.
Okay.
If you could just respond to my question. Is that correct?
The timestamp's been removed, yes.
However, the competitor of Celebrite that we just talked about, Magnet Forensics Axiom,
Yes.
that program at the first proceeding showed the 2:27:40 a.m. timestamp, correct?
Correct.
And as a matter of fact, as you sit here today, the magnet forensics program, Axiom, still shows the 2:27:4 a.m. timestamp, correct?
As far as I know, yes.
And Magnet Forensic Axiom is a reputable company, correct?
Correct.
Celebrite removed that 2:27:40 a.m. timestamp, which is in a deleted state, in response to issues raised in the first proceeding, correct?
It was changed because of the research that I did, and that was verified by the forensic research group.
But the issue arose because of what had come up in the first proceeding, correct?
In the first investigation prior to the proceeding, yes.
In the first investigation in this case, correct?
Yes.
So Celebrite, after the first proceeding, after the investigation, just outright went and removed the timestamp.
It's not unusual to change the
I
code.
didn't ask if it, I just asked whether they
we removed it.
But Magnet Forensic Axiom still shows that 2:27:40 a.m. timestamp, right?
Again, they refer to it differently, which is why they can
But
do
they
that.
still show it.
They do still show it.
Can you just finish the answer?
So,
Sorry.
Just let him finish the answer. Is that what you said, Mr. Mayor?
yeah, my apologies, but I'm having trouble hearing, but I'll pause more just to make sure you're done. In that 2:27:40 a.m. timestamp, the dispute is whether it's associated with the search, House Long to Die in the Cold, correct?
Correct.
Okay. So he's basically saying too that this is regarding a flaw in the software. They took it to this forensics group you heard him reference, and these other groups agreed that what they did, whatever they did was right, or it was 623 or 624, whatever. Axiom, this other software, this other group they're talking about, that Alessi is talking about, is something that the defense used. And so I think the defense is going to call somebody up from that company who's going to say, well, yeah, we have it, and this 227 is still there. We believe it happened at 227. And so they're going to, and he's saying, Alessi's getting him to admit, yeah, Axiom's as good of a group as any, or as good of a software as any. So he's vouching as Celebrite. It's supposed to be the gold standard. He's vouching for Axiom on the stand. So on redirect, Hank Brennan asked him a bunch of questions about this. Let's see, Melmac asked a question. Sorry, let me pull this up. I was going to play the battery temperature one.
Proceeding.
Oh, sorry. I was going to pull the battery temperature thing up. I'm trying to remove this one.
In regard to the first proceeding.
Goodness me, I'm having an issue here. Sorry, guys. I want to know if Whiffen has a gig with Axiom, asking for a friend. No, his only gig right now appears to be with Celebrite. And he said he would not ever do anything to hurt Celebrite. So he's not going to get up and say something that's, he's not going to do something that's going to damage the company or, what have you. And Alessi also suggested, because he used to be a cop, he's like, well, you help cops. You work with cops. That's what you do. And investigators, prosecutors. And he said, yes, I do. And so he's implying he has a bias toward law enforcement, toward that side, and that he would maybe fudge his results or do some things, or the company might, in order to help out the Commonwealth's case. So let's go now to the redirect by Hank Brennan, where he wanted to do a demonstration showing the jury how he came to his conclusions about how long to die in the cold search. Oops, here we go. He's turning back to the phone that was attributed to Jennifer McCabe. I'm wondering, how do you guys feel about Hank Brennan? It seems like a tighter presentation by the Commonwealth this time around. Thank you, Glitter is Forever. I appreciate that. You're making me feel good. This eye makeup has been on since 9 o'clock this morning. Oh, you're right. I didn't even think about that. Melmac says Axiom is all about body cam recordings for law enforcement and more. I didn't even think about that being the same Axiom. You're right, but maybe they have software stuff for cell phones too. So here's Hank Brennan on redirect, and he's like, I want to turn now to the cell phone of Jennifer McCabe or Jen McCabe. There was a whole, thing about him calling it Jen's usage or Jen's phone. I don't know if it's called Jen's phone. I know my phone's called Anjanette's phone or iPhone or something like that.
And you had shared with us your opinions about the time in which the searches at 6:23 and 6:24 were made.
Correct.
And I asked if you could just show us live right now how it works that a person can open a tab and there's a timestamp, a time when it's open, and then make a later search but still retain the original timestamp.
Yes.
Is that something you can do for us?
It is, yeah.
Okay. With the court's permission, I'd ask Mr. Whiffen to give
Yes.
us a live demonstration
Okay.
of this.
Do you want the light off, Mr. Whiffen?
The light off would be better, thank you.
Okay.
I'm turning this up to 1.25 speed, guys, just so we can pack a little bit more into our time together here.
Thank you, Dave.
Okay. First of all, I will highlight on the left side of the screen here, this is actually a live representation of what I have on a phone that's in front of me. So as I move this around, you can actually see on the screen that the screen refreshes. I'll also point out the iOS version here is 15.2.1, which matches that from Jennifer McCabe's phone. On the right side of the screen is the tool which I spoke about earlier, the one I've been writing for several years. I make it available for free for any examiner who wants to download it and research primarily iOS devices. Here, you can see I've got a live connection to the device. So every file and folder that is on the device I can see within this directory view as you would normally see on a regular computer. And we can see the browser state.db database. If I open that database up, you can see there are 4 tables, one of which is called tabs.
Mr. Whiffen, I hate to interrupt you. Can we make this larger? I know jurors earlier were hoping
I can
to
try to.
have a larger view of what's up there. Is that going to
better.
impact your demonstration in any way?
It shouldn't. I should be able to work around it. Thank you.
Is that better for the jurors?
Okay, perfect.
Yes.
It's just a little closer.
Let me pull forward.
Turn the air conditioning on.
So at this moment in time, the tabs table has 2 records. I'm just going to ask that you ignore those for now. They're from a previous demonstration. I can't delete those without taking longer to do this demonstration. I go back onto the phone itself. Just takes a second to refresh and open up Safari. And I can open up a new tab. What I will just do now is search for the time that we're on now, so 14:10, and hit go. So right now, that page is loaded. Sure. And I can go back into the database and just hit reload. That will bring the most recent version of the database from the device back onto my computer and show it back in this window in exactly the same way as I was viewing it a second ago. And you can see right now there's still only 2 records. So the fact that I did a new tab and a new search has had no effect on what I can see. This is different to on previous versions of iOS, where you would already now see a new record with the 1410 search, which I'd made. I'm then going to do another search. Hopefully it's going to catch up with me. It's now 1411, so I'll do a search for 1411. Okay, we can see the page is loaded, and I can go back over to this tool and reload the database. We still don't have a new record that shows that a search is being conducted. I'll just take the time to do another little search and just do 1411X. Reload the page again. Still, nothing's appeared. I can even close down Safari, just minimize it into the background, and then bring it back into the foreground by just pressing the Safari icon. I can hit reload again, and we still don't have a new record, and I can do a further search for now 1412. 1412 is loaded, and I can reload the page. Still no records present. I can now go into Safari and just close the tab. So now that tab is closed, and I can just prove that. So that tab is now closed, and I can go back over here and reload, and you'll see a new record has appeared. I'm just going to change the time zone just so that this shows accurately, and tell my tool to treat the timestamps as Eastern time. So we look at this particular record, and you can see The title is 1412. That's the last item that I searched for. You can see the URL is the google.ca /search 1412. Again, that is the content that I searched for. And then we see this field here, the last viewed timestamp. And the time here still says 1410 because that's the time that I first loaded the tab. The fact that I navigated between, the fact that I minimized and reopened Safari, there's no relevance to this timestamp. It is purely the timestamp that tab was created or brought back into focus.
To an untrained eye, can that development of a timestamp become confusing?
Yes, the name last viewed time clearly has implications that would make you believe that it was the time that the page was last viewed. It's a very simple test that I just demonstrated to prove that that's not the case.
Is there any other reason that Celebrite removed that process of timestamp other than to clarify that issue?
Objection, Your Honor.
No, I'll allow it.
Purely because we determined it was unreliable to use as a time that the page was last viewed.
If an examiner simply made a report from Axiom or Celebrite or another software but didn't have the time or skill to actually go into the data, could they be easily confused by this?
Yes, the way that Celebrite provided this information showed as last viewed timestamp. The way that Axiom provides this data is called last interaction time. So there is some leeway there to misunderstand it less from Axiom because it's talking about tab interaction rather than a web page that was last viewed.
Thank you. I have no further questions.
All right, thank you. The light's on, please. Mr. Alessi,
Briefly, Your Honor, if I may.
Yeah.
Thank you.
do you want Mr. Whiffen to take this down?
Okay, so he's explaining, you know, I don't know if you guys followed all that. I followed it as I was watching it, but I'm not going to try to explain it. But in the last trial and I guess in this trial too, I think we'll hear from Jessica Hyde too, because Hank Brennan brought her up as well. Jessica Hyde, she's another forensics expert for the Commonwealth. They testified that the search, in their opinion, by Jennifer McCabe happened at 6:23, 6:24. The house long to die or host long to die in the cold search. So, you know, I don't know how many people are in here on either side of the fence. I've said before, everybody's welcome. I just want everybody to treat everybody with respect. I see how nasty things get on X and everything. I don't talk to people like that, and I'm not going to let people talk to people in my chat that way. So whatever side of the fence you're on, you're more than welcome to comment on this. And again, thanks for watching and being here. And please like and subscribe. And if you're watching on replay, I really appreciate that as well. But Jessica Hyde will be testifying for this Commonwealth again, I think, too, saying that she believes this search happened at 6:24. I kind of wonder, is this going to come down to, does the jury just believe Jennifer McCabe or not? Is it going to come down to that? It may be that simple. So let's watch the redirect, or the recross, pardon me, by Robert Alessi of Ian Whiffen.
Yes, please, Your Honor. Good afternoon, and hello again, Mr. Whiffen.
Good afternoon.
Magnet Forensics Axiom still shows a 2:27:40 a.m. timestamp on its forensic tool, correct?
Correct.
And Magnet Forensic is a reliable forensic tool company, correct?
As reliable as they come, yes.
The demonstration that you just performed, when did you create it?
The demonstration?
What you just,
Like literally just now as I was doing it live.
so you
Is that
just
what you mean?
created the demonstration now live on the stand?
That particular demonstration, yes.
Okay. So that demonstration, therefore, was created after Celebrite removed the 2:27:40 timestamp from all of its tool programs, correct?
No, incorrect. I mean, that demonstration I just provided was right now, it was live. Initially, when I did these tests, I did the same kind of experiment, the same type of testing back in late 2023, I believe. And after I did those tests and used that research, that is when Celebrite removed the timestamp.
Maybe my question wasn't clear. Let me see if I can rephrase it. The demonstration that you just gave, When did you prepare it? The demonstration, not just the demonstration that you just showed on the screen. When did you create that demonstration on your computer?
Hey, again, I've been doing this demonstration for 2 years.
My question, again, is the demonstration you just gave.
Yes.
When was the last time you altered that demonstration?
Other than to use different search terms, it's the same demonstration.
I'll try to differ.
Yes, please.
When was the last time you altered in any way the demonstration you just gave?
Right now.
So you altered it right now, and that alteration was made after Celebrite had removed the 2:27:40 a.m. timestamp from its programs, correct?
Yes. Okay.
Thank you. No further questions, Your Honor.
Mr. Wigan, you are all set, sir.
Thank you.
Very much.
May we be seeing why Mr. Whiffen is collecting his items?
So, yeah, I think it's just going to come down to it may, this whole battle of the experts thing, it may come down to who they felt was who the jury feels is the most trustworthy. And do they believe Jennifer McCabe or not? Do they believe Carrie Roberts or not? So Jennifer McCabe, I think, the minute I saw Ian Whiffen come up to the stand yesterday and start talking about the 227 versus 623 thing, I was like, oh my gosh, they're going to put Jennifer McCabe up pretty soon then. And here she is. So let's watch a little bit of Jennifer McCabe.
All right, Mr. Brennan, whenever you're ready, Mr. Wigan, I'd ask that you pull the microphone closer. Thank you.
Thank you, Your Honor.
Go right ahead.
Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury?
Hi, I'm Jennifer McCabe, MCCABE.
Ms. McCabe, how old are you?
I'm 49 years old.
Are you married?
Yes, I am married with 4 daughters.
Without detailing your children's names, can you tell us a little bit about your family?
Sure, I have 4 daughters that are 16, 17, 19, and 21.
I'm going to speed this up a little bit, guys, so we're not sitting here like all night long. But here, I'll speed it up a little bit, and I'm going to refill my water, but I'll be right back.
2 are in high school and 2 are in college.
In raising your children, was your family active in local sports?
Yes, all 4 of my daughters played multiple sports from when they were young. 2 now are playing in college. My husband and I both coached them. My husband coached them from when they were young up through 8th grade in soccer, and I coached them in basketball.
Without telling me your address, what town are you from?
I'm from Canton.
How long have you lived in Canton with your family for?
I was born and raised in Canton, and now I'm raising my family there.
So your family, their whole life, you've raised them in Canton?
1 year, we lived in Stoughton with my daughter.
Who do you live with now?
I live with my husband and my 4 daughters.
Can you briefly give me a little bit more background on your children's school and your participation in that and interaction with your children, raising them?
Yeah, so I was a teacher, and then once I had children, I stayed at home with them and basically was just kind of like your typical, small town mom. I was the room parent. I coached them.
No, I'll allow it when we
Yes.
move on.
When I coached, I drove the kids back and forth on my team, would take them places, etc.
In the growth of your family and raising your children, at some point did you meet a gentleman by the name of John O'Keefe?
Yes,
Share with us meeting John O'Keefe.
sure. When my 3rd daughter was in kindergarten, she became friends with John's niece. And during that kindergarten school year, unfortunately, Kaylee's mother and father both passed away, and John moved in the house and became Mr. Mom.
When John took over guardianship of the children, did you assist in an active role in helping him?
Yes, Kaylee and my daughter were very close. So she would come over and play. My daughter would go over there. Kaylee would come and have sleepovers. A lot of times it would be on Friday nights. I would have Kaylee, and then another individual would have Patrick.
Had you known John O'Keefe well before he took over guardianship of the children?
No.
During the time when he was the guardian of the children, did your relationship, not just with his niece and nephew, but with him, grow any closer?
Yes, we became very good friends.
How close of friends did you become over the years?
Well, throughout the years, obviously, when they were younger, we talked more, just about the logistics of CCD, pick up, drop off, basketball, sports. But then he would also call me, about, as the girls got older, the girl drama or, the hormones and things like that. He would also come over, and hang out and have a beer and, just talk about whatever was new in his life or going on, or, just the day in and day out struggles of his, life and raising the kids now and figuring it all out with, work and family and all that.
Leading into January 28th of 2022, so the jury understands, how close was your friendship with John O'Keefe at that time?
He was a very good friend of mine that I knew I could call for anything.
I want you to take us forward to January 28th, 2022. Do you remember that day?
Yes, I do.
Do you remember it well?
Yes.
Take us to the early morning hours, January 28th, 2022. Did you learn there may be weather or a storm coming?
Yes.
Tell us a little bit about that.
We all saw the report that there was going to be a big storm, a nor'easter. So we all knew that basically all the Saturday activities were going to be canceled.
That includes sports?
Yes.
Was and is the sporting events for the children a big part of your life?
Yes. Back then I had, 2 in high school that played 3 sports, and they played club sports as well. And then the 2 middle school played club sports and town sports. So most of our weekends were taken up by kind of running from one sporting event to the next.
When you learned about the weather and the changing schedule, did it change your plans for that day?
No, not particularly. I had my day was pretty set out. I had my niece, and then I had sporting events. It was kind of my plans for the next day that obviously got changed.
Take us through the afternoon of the 28th. What's happening?
Well, I had my niece for the weekend. She was picked up. My oldest was on the hockey team, and she was having a team dinner at the house. So I picked up pizza, got desserts, set it up for them. And then I left with my daughters and my husband, Matt, and we met some of the parents from the high school basketball team at a local pub to grab a bite and a drink before the basketball game, because my other daughter played on the high school girls basketball team.
What time was the basketball game set for that night?
I believe it was 6 or 6:30.
Did you and your family go to the game?
Yes, we did.
Vermont Brad Smith says, didn't say this in the first trial. I think are you talking about like the stuff about John being Mr. Mom and all the, the background info about their relationship and stuff like that? I don't know what you're referring to. I mean, it's a different prosecutor this time around. So he has a different style. So I feel like he moves more quickly through the witnesses. Hank Brennan does than Lally. So I feel like, he's painting more of a picture about Jen McCabe's relationship with John O'Keefe. So, I don't think that's a big deal. But let's continue to watch. And I might scroll forward a little bit, through them being at the waterfall and all this jazz, and just get to, the meat of it. Yeah, Alexa Weasel. I think, Brennan's been doing this a really long time. He's got more experience and done more trials than Lally has. So I think that he just has a much different style, and he knows how to draw the answers out that he's looking for, what he thinks is important and what will be important to the jury for whatever reason.
After the game, what happened?
After the game, I drove my daughter home. My sister, Nicole, sent me a text and said that she was going to be at the waterfall, and it was my nephew's birthday. He was going to meet up, and did I want to come by for a drink?
What is your nephew's name?
Brian Jr.
It was his birthday that night?
Yes, it was.
When you received a call to meet with friends and family at the waterfall, do you remember what time that plan was made?
I don't. My sister sent me a text at some point letting me know she was going to be there, so I don't know what time.
After the game and after some time, did you go to the waterfall to meet your friends and family?
Yes, I did.
Describe very briefly, what's the waterfall?
It's just a local town bar.
Do you remember about what time you got to the waterfall?
About 9 o'clock.
When you got there, was there anybody there that you knew?
Yes.
Okay, now take us inside. Did you make plans with him, or did he just show up?
I believe he had started the conversation about the night with Chris Albert.
Okay. Chris Albert is a different Albert than Brian Albert?
Yes.
How was the relationship between them?
Brian Albert and Chris Albert are brothers.
Was Chris
Webby asks, he was a defense attorney, wasn't he? Now turned prosecution. I think you're asking about Hank Brennan. Yeah, he was a prosecutor for a long time, but then became a defense attorney. He represented Whitey Bulger in his federal trial, but he was a prosecutor first. Like a lot of lawyers, they're prosecutors first, and they become defense attorneys. And now he's been hired as a special prosecutor in this case, which that's not completely unusual. I've seen that happen where defense attorneys are hired on as special prosecutors because typically they have backgrounds in being prosecutors. Not all defense attorneys would do that, but obviously for whatever reason, and maybe someday we'll learn the backstory of how that came to be.
Chris Albert there when Mr. Higgins and Brian Albert arrived?
Yes. Actually, Chris, did I miss him? Because Chris was there with Julie. Did I? I'm not sure if I said that when I was naming everyone at the table. I apologize.
You may have.
Okay.
So when you first got there, he was at the table with your
Yes.
sister?
Yes, he was.
When moments before John O'Keefe arrived with the defendant, what was the mood in the group?
Cheerful. Good mood. Everybody was just out having a drink. We all knew the storm was coming tomorrow, and just a typical average night.
Celebratory?
Yeah.
You said you were going to see Brian Albert Jr. for his birthday. Was Brian Albert Jr. at the waterfall when you got there?
No, he was not.
Was Brian Albert Jr. there anytime when you were at the waterfall?
No, he was not.
Without relating a conversation with some other person?
Yeah. Alexa Weasel says, I like Brendan's choice of words. Now take us inside the bar. Yeah, I agree with you. I like that style because he's like, now take us inside the bar. Like, like it's very to the point and very conversational. It keeps you engaged, I think. And plus we're watching on like 1.5 times speed to get through this.
Person. Did you have an understanding where Brian Albert Jr. was?
He was at home.
Did you historically or typically see Brian Albert Jr., your nephew, on his birthday?
Yeah, typically we always, get together. We try to and do a cake for whoever's birthday it is. And then whatever, aunts or cousins are around, come over.
When John O'Keefe arrived at the waterfall with the defendant, do you have a general estimate or guess, not guess, but a general estimate of what time they arrived?
Approximately 11.
When they first arrived, did you see them?
Yes.
Where did you see them coming from?
I saw them walk in.
All right, let's skip ahead a little bit. We don't need all the minutia.
Like I said earlier, a couple of drinks, 2, 3, not sure.
Did you ever have a shot of alcohol?
I do not believe I had the shot now.
Did you see the party, the group of friends and family doing the shot?
I was in the bathroom and walked out, and they were doing or had just done a shot.
Okay. With the court's permission, I'd like to display parts of Exhibit 22, which has already been introduced into evidence, which is video surveillance footage from the waterfall.
Okay.
I'd like to start at 10:54:20, please. If you could just stop for 1 second. Do you recognize what's in that video?
Okay, so there's inside the waterfall. I don't think we need to go through that whole thing.
It wasn't an uncommon occurrence for the group to sometimes go to that pizza shop after hours, was it?
No.
Did the group decide to go to the pizza shop?
They decided they weren't going to go.
Okay. Was there a different plan made?
Before Brian Albert left, he said to the group, hey, we're going to go back home and have a beer with Brian Jr. If anyone wants to come by.
When you received the invitation to the group to go back to Brian Albert's house, did you decide whether you're going to go home or go back to your sister's house?
Yes, I decided I was going to go to my sister's house.
Without saying what was said, was there any discussion in the group among the participants about going back to your sister or Brian Albert's house?
Everybody seemed to want to go back.
Did anybody object to going back?
No.
Had you been to your sister's house before?
Yes.
Many times?
Yes.
Do you know the address of where your sister lived?
Yes.
And so after that conversation, did you stay at the waterfall for a little bit or did you leave immediately?
Probably left after maybe 5-10 minutes.
Without saying what was said, before you left, did you have a chance to speak to John O'Keefe?
I did, yes.
You spoke to him inside the waterfall?
Yes.
Did you have a chance to speak to the defendant?
Yes.
And was your plan to go back to your sister's house?
Yes.
Before you left, did you have any understanding whether or not Mr. O'Keefe and the defendant were going to join you?
Did you have an understanding regarding that?
Yes.
And what was your understanding?
They were coming.
Who else was going to go back to your nephew and your sister's house?
Brian Higgins and my niece, Caitlin.
A little after 12, did you leave the waterfall?
Yes.
Do you remember that night leaving?
Yes.
Before you left, did you talk to anybody in particular?
Yes. Miss Reed and then Mr. O'Keefe.
Did you speak to them inside the waterfall?
I walked out with Miss Reed and we spoke at the doorway, and then John joined us.
Did you invite Miss Reed to come with you?
I did, yes.
Did she decline?
Yes.
And who did you go to your sister's house with? Who drove?
I drove and I went with my husband, Matt.
Anybody else?
No.
Do you remember what time it was that you were speaking to Miss Reed about going to your sister's house?
After midnight.
If I could have Exhibit 22 again. Ms. Gilman, if you could take us to 12:10:36.
Okay. Let's skip past this.
Did
Did he ask you for help trying to find the address?
I'm not sure his exact words, but yes, he needed help. And so I just said, I told him, just go down the street, go by Bella's house. It's at the bottom of the street.
So you used Bella's house as a point of designation to try to guide him to get to your sister's house?
Yes.
Tell us who Bella was to John.
Bella is my daughter and John's niece friend. So Bella is friends with my daughter, John's niece.
Okay. And was there any relationship between Bella's mother and John that you knew of?
Okay. So there's been discussion that there's been Phil says how rude they did the shot when she was in the can. hilarious. But I don't think she minded. But there's been speculation, people wondering if the fact that John O'Keefe dated Bella's mom at one point in time somehow sparked, because of the mention of Bella's house, Bella's mom, did that spark some kind of argument in the SUV? And maybe that contributed to the argument in the car. So that's been kind of bandied about now for some time. So let's get back after the sidebar.
Tell us generally when you first.
I say that in the nicest possible way because I love the accents up there. The accents are amazing. And I jokingly told people at work we should just talk in Massachusetts accents all week because I love the accents.
It would be after 12:15, but before 12:30, approximately, between that.
Were you still driving when you had that conversation?
Yes.
And at some point you told us you arrived at your sister's home and went in.
Yes.
Okay. I'd like to move forward now to when you were inside the house. Tell us generally when you first got there and saw everybody, what were you doing?
I just sat down at the table. I started talking to them. We were listening to music. Typical night.
Okay. Anything stand out as far as music or interaction with the group?
No, we were just laughing, telling stories. At one point, I'm not sure if it was at some point, my other nephew had been over my house and had shown me this video on his phone, and it was a family inside joke. The video, it was a music video from a long time ago, and so I was telling my other niece and nephew, "Oh my gosh, you have to see this video. It's hysterical." And then we started playing it and watching it.
What was the video?
It's Raining Men.
Did that get a lot of playtime during that get-together?
Well, I have one sister who sometimes has a little too much to drink, takes out an umbrella, and will dance. So it's a family joke.
While you were at your sister's house, what area of the house were you spending time in?
And I was in the kitchen.
What was the mood of everybody in the house as far as you remember?
Everybody was in a great mood.
Was there any fighting?
No.
Any arguing?
No.
Any violence?
No.
Was it a celebratory mood?
Yes.
As you were in the house, were you waiting for anybody else that you expected to come?
Yes, I was expecting John and Karen to come.
At some point when you're in the kitchen, or let me ask you a little background. As you're in the kitchen of that house, can you see outside from the kitchen area?
They had blinds or something down, but if the blinds were up, you could see out.
Were the blinds up?
No.
At any point were you able to see outside from inside the house?
From the front door, yes.
Does the front door, is it glass?
Yes.
At some point when you were with everybody in the celebration, did you have a chance to look outside?
Yes.
And when you looked outside, what did you see?
I saw a dark SUV out front.
Did you know whose SUV that was?
I believed it was Karen's.
Could you see who was in it?
No.
At that point in night, what does the weather look like from the front door?
It's dark and it's snowing, and I could see, brake lights.
Did you see if that SUV moved at all?
I didn't see the SUV actually move, but I saw it in a few different locations.
How many times did you look out?
Can't give you an exact number of how many times I looked out. I can tell you I saw the vehicle first straight out from the front door. Then I saw it up at the flagpole, and then I saw it further up from the flagpole.
Were you studying the car at all?
No, it was quick glances.
Did you have any reason to study it?
No.
What were you expecting was going to happen?
I was expecting John and Karen to come into the house.
Did they ever make it in the house?
No, they did not.
As you were waiting, were you doing anything else in addition to waiting for them to come in?
Yes, so I was sitting at the table. Someone made mention of a car out front, so I got up, went to the door, looked out, and then I would go back to the table, and where we were just all laughing, talking, playing music, just hanging out, not really thinking much about anything.
Did you ever reach out to John when you thought the car out front was the defendant's car with John in it? Did you ever reach out to him?
Yes, I did.
How did you reach out to him?
I texted him.
Do you know if there was a phone call that was made to you before 12:30? A 7-second phone call?
From John?
Yes.
I don't.
You mentioned you had spoken to him about directions. Is that the last time you heard his voice?
Yes.
When the car was out front, did you exchange text messages or were you simply texting him?
I was texting him.
Do you remember what you were texting him?
The first time I said here.
What do you mean by here? Was that
Like hair question mark, because that's when I saw the car.
You were wondering whether that was him?
Yes.
Did you send any other text messages that you can remember?
After I saw the car move locations, when I saw it go up to the flagpole, I said, pull behind me.
And do you remember any other communications you had with him? Was he texting you anything?
No.
Did he ever text you again that night?
He never texted me again.
Never called again?
No.
Did you continue to text him over the next 15, 20 minutes?
I did, yes.
And so at some point, did you realize that John O'Keefe and the defendant weren't coming in the house?
Yes, when the car was gone.
Did you ever go outside through the storm down to the flagpole to speak to them?
No.
Why not?
Why would I?
I was just asking.
I had no reason to.
So when you were in the house, at some point, did you notice that the car was gone?
Yes.
Were you marking the time or keeping track of it?
No.
After you didn't see the defendant's car anymore, did you stay?
Yes.
How long do you think you stayed for at the house?
I stayed till about around 1:30, 1:45-ish.
Did anybody else come in the house up until 1:45?
No.
Did people leave at certain times?
Yes, people did leave.
Who was the first to leave?
Brian Higgins.
Do you remember about what time he left?
I don't.
And after Mr. Higgins left, do you know who left?
I'm not sure. I believe it was us, and then my niece Caitlin was also like at the door. It was kind of in a row. Brian left, and then a little bit later, I think it was myself, Matt, Julie, and Sarah left. But Caitlin was at the door. I believe she was waiting for her ride.
How much longer after Mr. Higgins left did you leave?
Maybe I honestly can't say. I think he was there for a while I was there. So maybe he left anywhere from 15 minutes, approximately 15, 20 minutes before I did, or maybe a little more.
You mentioned that you had left the waterfall after midnight,
Yes.
and you had phone calls with Mr. O'Keefe along the way.
Yes.
Do you know that there are phone records with your text messages and phone calls in them?
Yes.
And do you know whether your phone records reflect the time of your calls with Mr. O'Keefe
Yes.
and your text messages?
Yes.
When you were texting and Mr. O'Keefe, when the Lexus or the car was in front of the house, rather, was Mr. Higgins still there?
Yes.
What are some of the things that everybody did along that night before you left? What happened in there?
What happened inside the house? Nothing. We basically just sat around the table, talked, laughed, listened to music, chit-chatted.
Celebratory?
Yes.
Was there ever any fighting?
No, none at all.
Any arguing?
None at all.
Any physical interaction?
No, none.
When you decided to leave that night, did you say around 1:45ish?
Yes.
When you left around 1:45, was there any events that happened that night that would cause you unrest or excitement or your heartbeat to raise?
No.
When you decided to leave, you and your husband, where were you going to go?
We were dropping off Julie Nagel and Sarah Levinson, and then we were going home.
Had you planned on dropping them off earlier in the night?
No, when we got there, Julie's brother had pulled up to pick them up, and
I want to ask you what was said because you weren't there.
Oh, okay.
At some point, did you come to an understanding that you would give them a ride home?
Yes.
Did you offer?
Yes.
Who was going to drive home between you and your husband?
Matt drove home.
When you left, I want you to describe as you step out into the driveway or the walkway. Was it the front door or side door, if you remember?
I walked out the front door.
Is the weather like it was when you first got there?
No, it's picked up.
Tell us what you mean by it's picked up.
So as I walk out, you kind of go, the walkway is to the left. So I walk down the steps, I go to the left. The snow was coming, it was cold, the wind was picking up. So I kind of just like curled up and ran to my car quick to get in.
What part of the car did you get into?
Front passenger.
Who was driving?
Matt.
And where were the other two people?
Sarah and Julie were in the back seat.
Who was in what spot?
I'm not exactly sure.
So both of the young women were in the back seat?
Yes.
Was there any conversation when you got into the car?
We got in the car and they were teasing me
Why were they teasing you?
because I had like bread and maybe peanut butter in my car.
Why did you have bread and peanut butter in your car?
I had my niece for the week, and I was dragging her like to all my kids' sporting events. So we go from like one game to another game to a practice. So sometimes instead of always giving her McDonald's or Dunkin' Donuts, I'd try to throw her a peanut butter sandwich.
And they were making fun of you?
Yeah.
As the car backs out of the driveway, tell us what you're doing.
I'm talking to the girls.
You just moved your head.
Yes.
Does that mean anything?
Yes.
How?
They were both sitting behind me, so I was like turning and chatting and talking.
After your husband pulls out of the driveway, do you start to drive home?
Yes.
If the house is on my right, and you're driving, are you in the passenger seat closest to the house or furthest away?
Passenger seat closest.
So you're driving, if you look at a picture of the house, you would be driving from right to left?
Yes.
So as you start to drive, or your husband starts to drive the car, what direction are you looking in, if you remember?
The back seat.
Did you drive by the front of the house, do you know?
We pulled out of the driveway and went up Chapman.
Okay. And your husband and you passed by the front of the house?
Yes.
Did you pass by the flagpole?
Yes.
Were you looking at the flagpole?
No.
And how dark was it at that point?
It was dark.
Snow?
Yes.
As you're passing the flagpole, do you hear or see anything remarkable?
No, I'm not really paying attention. I'm just chatting to the girls, and Matt's just focusing on driving.
When you're talking to the girls and they're making fun of you, what's the mood in the car?
We're all laughing and joking.
Where do you go next?
We drive Julie Nagel home.
After you drop off in Sniggle, where do you go?
We drop off Sarah Levinson.
Is the weather constant?
Yes.
After you drop off the young woman in separate spots, where do you go?
We went home.
Can you tell us when you get home what happens next?
We go in the house. I go up to bed. Matt makes himself a snack and then joins me upstairs.
Do you have a telephone?
Yes.
An iPhone?
Yes.
When you go to bed, do you stay up at all?
Yes.
Do you use your iPhone?
Yes, I do.
What were you doing?
I texted a few people, and then I did a couple of Google searches.
And what were the searches for?
One, my daughter had played in a basketball game earlier in the night, and it was a very good game, so I went and I read the report on it. And then my other daughter had an offer to play on a basketball team, so we had to make a decision about whether or not we were going to accept the spot. So I was just looking up that basketball club.
Other than those regular searches that one would do, was there anything remarkable about what you were searching at 2:27 that time frame?
No.
After you were looking at websites for your child's sports, what did you do?
I put my phone down and went to sleep.
And up to that point, had there been any discord or fighting or arguments in your world?
No.
Peaceful night?
Yes.
Did you go to sleep, Ms. McCabe?
Yes.
Did you sleep through the night?
I typically get up to go to the bathroom, so I could have gotten up possibly to go to the bathroom.
Did anything remarkable happen in the early morning hours of January 29, 2022 that changed that peaceful mood into something else?
Yes.
I want you to share with the jury the first thing that happens that changes everything.
At 4:53, my phone rings, and I look at my caller ID. I look at the phone, and it's Kaylee, John's niece. John's niece. And I say hello, and she said, "Yeah." Well, basically, she relayed to me that. Next question.
When you pick up the phone, could you hear a voice on the other end?
I heard a voice and a lot of screaming.
And the voice you heard, is that Kaylee, John's niece?
Yes,
And the screaming, was it a man or a woman screaming?
it was a woman.
How loud was that person screaming?
Very loud.
Could you make out anything that person was saying as they were screaming?
My name was screamed a lot. And then the other individual ended up getting on the phone with me.
And who's that person that was screaming in the background?
Miss Reed.
How long was she screaming for while you were speaking to your niece before you spoke to her?
The entire time I was speaking to Kaylee, she was screaming.
Describe her demeanor.
Miss Reed's?
Yes.
Jen! And then she's screaming that John didn't come home. She left him at the waterfall. She was hysterical. It was very hard to follow what she was saying.
How long did that first call last for?
I'm not sure how long, maybe possibly a few minutes, but it was loud enough and long enough that my husband shot up in bed thinking one of my kids had come in the room screaming.
Without saying what your niece said, could you describe your niece's demeanor when you first spoke to her? I mean, John's niece's demeanor.
I would say Kaylee sounded concerned, uneasy.
Okay. During that phone call, other than the screaming and the screaming of your name, did the defendant give you any information other than she had dropped John off at the waterfall?
They had gotten into a fight. She had left him there and he didn't come home.
And when you were woken up, were you in sleep when you were woken up?
Yes, I was sound asleep.
What was your mental state like when you first woke up and got that call?
Well, I had been up late. I had taken my medication that I take for my MS, so I was definitely a bit groggy when I first woke up. So immediately I just wanted to help her. She was hysterical. Kaylee was upset. So I went into that kind of mom mode of what can I do? How can I help? So I immediately was like thinking, okay, well, if you left him at the waterfall, let me think who was still there, or, how can I help you? How can we find John?
Did you have a plan when you ended that first call?
I did. I knew Chris Albert had still been at the waterfall when I left. So I thought if Karen and John had gotten into a fight, maybe Chris had walked out of the bar and Chris lived local to the bar. I thought maybe they walked back to Chris's together.
So what did you do?
So I called Chris Albert's wife, Julie.
Did you speak to her?
No, she never answered.
After you had a moment to make a phone call and think about things, did your head become any more clear?
It did. And I was, reminded by my husband that we had seen Karen and John's car outside of Fairview.
When he reminded you, did you independently remember the text messages that you sent to John earlier that evening?
Immediately, I was like, oh my God, you're right.
Did you remember that you had seen what you believed to be the defendant's car in front of the house near the flagpole?
Objection. Watch the form.
Okay. What did you remember? What came to mind after you spoke to your husband about your memory from earlier that evening?
The minute he said it, I remember seeing the SUV and then all the text messages that I had and the phone conversation with John.
So after the defendant spoke to you and said she had left the defendant at the waterfall, and you had time to think about your memories, did you react or do anything with that?
Yes, I believe I called Kaylee back.
Why did you call Kaylee?
I didn't have Miss Reed's phone number.
When you called Kaylee back, did you speak to anybody?
Yes, I believe Kaylee and then Miss Reed.
When you first spoke to Kaylee, could you hear anything other than Kaylee?
The screaming.
Was it any different, or was it similar to the first time you spoke by phone?
Similar to the first time.
Regarding the demeanor or intensity, had it changed at all?
Not at all.
You mentioned the first time that you had that phone call, the defendant was before or after you had told her about seeing her car?
When I said I saw you.
Okay. So she tells Karen Reed she saw her car.
I saw you guys outside of my sister's house. And then she told me she didn't remember being there. And then she went on to say, she started saying, could I have hit him? Did I hit him? And then she just was just all over the place, like screaming my name, screaming so many different things. She was hard to follow or understand.
When she was saying to you, did I hit him? Could have I hit him? Was that before or after you informed her that you had seen her out front of your sister's house?
It was after I told her that. She also informed me that she had cracked her taillight.
In that conversation, she told you that?
In one of the conversations I had with her in my bedroom, yes.
When you told her that you had seen her out front, she had said that she didn't remember that night. Was that before or after she was saying, did I hit him? Could have I hit him?
Can you repeat the question? Sorry.
She was telling you about that she didn't remember that night. Was that before or after you had told her about seeing her car?
When I said I saw her at Fairview, then her response was she didn't even remember going there.
Did she ever deny that she came to Mr. O'Keefe's house? I mean, to your sister's house?
No.
When she told you or said to you, did I hit him or could have I hit him or something like that, did you have any idea what she was talking about?
No, I didn't pay attention to it.
When she told you that she had cracked her taillight the night before, did that have any significance at that time to you?
No.
So in telling you these different things, did you ever piece them together at that time?
No.
What was your primary motivation at that point?
I just wanted to help her because she was hysterical. Kaylee was very upset, so I wanted to help her, and I wanted to find John.
So after she told you these things about whether she could have did hit her and the light and not remembering, did the conversation end or did it progress?
At some point, I was then going into like, okay, well, if she brought him there and left him there, where was he? Because he never came in the house, and she doesn't know where he is, so now where could he be? So I started thinking there was another gentleman that was supposed to meet us out at the bar who John was friends with. So I thought, okay, well, in my head, I'm thinking maybe they got into a fight. John got out of the car, and he connected with this guy because he was at a party on the street.
What was that person's name?
His name is Tom Beatty.
Did you call him?
Yes.
Did you get a chance to speak to him that night?
That morning?
Yes.
No.
Did you call around anywhere else?
I believe I called my sister. I called John. I called Tom Beatty. I called his daughter.
You called John O'Keefe's phone?
Yes.
Did he answer?
No.
Did it go right to voicemail?
I don't remember.
Did you text anybody?
I honestly don't remember if I texted. I primarily think I was just trying to call as many people as I could and try to figure out what happened.
So you had two conversations at this point with the defendant while you were still home?
Yes.
Was there any further phone calls that you had before you did something?
I'm not sure if I know I went downstairs to make coffee because my plan was to go with my husband. I said, come on, let's just go over to Tom Beatty's. Let's see. Maybe John's there. He passed out on the couch. I'm not sure if Karen called me again or not. It's a little foggy because there was so many calls and everything.
And so that morning when you were receiving calls, did something happen?
Karen showed up at my house.
How did you know Karen showed up at your house?
I could hear her screaming out front.
And about what time is this?
Approximately 5:20, 5:30. I can't be
Were
sure.
you worried for John at this point?
Not particularly, no.
Were you screaming?
No.
Now, at this point, this moment, when you hear her outside of your house yelling, early morning hours, did you know a person by the name of Kerry Roberts?
I knew of her. I'd met her once.
Were you friends with her at that time?
No.
Had you?
So what do you guys, I think I'm going to stop the testimony here. What do you guys think of Jen McCabe's testimony so far? Do you think she's truthful? Do you think she comes off credibly? What do you guys think? Psychosaurus Rex says, if Jen is on some conspiracy, why wouldn't she ignore KR and act like everything is fine instead of going with at 6 a.m. after going to bed at 2 to help her look? She's not a great actress for it to be fake. Interesting. Hi and welcome, Psychosaurus Rex. Mel Mac does not believe Jennifer McCabe. So I'm going to stop her testimony there. It will continue tomorrow. The ARCA experts are being allowed to testify. But there was a big brouhaha about that. I'm going to scroll to the end of the day on that. And Judge Cannoni basically said that here's what Judge Cannoni said about this whole ARCA thing. The Commonwealth wanted them precluded from testifying. They said that the relationship was misrepresented basically to the court and to the jury. There were text messages destroyed between Dr. Wolf and Alan Jackson and not turned over to the Commonwealth. And also there was a question about Dr. Wolf and Alan Jackson communicating via signal. So here you go. Here's what Judge Cannoni said. I guess I didn't share this right. Sorry.
No applicability to this proceeding. Can I finish my answer?
Right ahead.
Has no applicability. That rule is intended to be between an attorney and the client. The court has no jurisdiction to enforce that rule.
I agree. That's a different body, but I'm asking you how I reconcile that when I'm trying to figure this out. Mr. Leslie, you know what? You're going to win this, so why don't you just let me make my ruling, okay? So I understand there have been repeated violations of the reciprocal discovery orders and my orders, repeated and deliberate. But, and Mr. Brennan, I understand completely the Commonwealth's argument, completely the ambush that has been set upon here. However, a defendant's right to a fair trial is paramount to everything. So I'm going to allow the ARCA witnesses to testify. I am going to allow what I expect to be a very robust cross-examination, and I'm going to allow them to testify to everything that they said up until yesterday. So you'll get the report May 7th, and I know that's late, and if you need anything as a result of that being late, I'll hear you on whatever motion you have. But that's where we stand, and I expect counsel to comply with all rulings and rules of the court and all rules of professional conduct, and no more nonsense. Let's just try this case. All right, that's it. I'll see you tomorrow.
All right, then, please.
So she was upset about the signal chats and the text messages being deleted, all of this stuff. She was angry, but she's letting them testify. I thought she might possibly not allow Dr. Wolf, and maybe they'd have to sub in this other guy for Dr. Wolf, but she's letting them testify, and she said she expects a robust cross-examination. So she's going to let Hank Brennan essentially go after them. So there you go. Jen McCabe's testimony will continue tomorrow. Everybody, thank you so much for being here tonight. I really appreciate it. Please remember to give me a thumbs up, like, and subscribe, all that good stuff. And I will see you back here another time. Thank you to Webby and Melmac for helping me out and moderating. And thanks to everybody for watching tonight. I will see you back here another time. Have a great night. Bye-bye.